plan to turn all critical voices into merely the opposition and thus render them dismissible.
Josh Blackman is a professor of constitutional law at South Texas College of Law. His latest book is Unraveled: Obamacare, Religious Liberty, and Executive Power. Welcome to you.
Thanks for having me back.
President Obama, of course, famously criticized the United States Supreme Court with the justices sitting in front of him when he was delivering a State of the Union message to Congress. How different is what President Trump is doing from what President Obama did?
Well, I'll give you a different example. The State of the Union case was somewhat different because it was about the Citizens United decision, which was already done. A better example is when you discuss pending cases. And in the run-up to one of the Obamacare decisions, the president said that I hope the Supreme Court plays it straight, that is, rule in favor of the government. And the implication there was that if the Supreme Court doesn't, it'll be playing it crooked, or you might say rigged, and doing it in a fashion that was not based on the law. In President Trump's own inarticulate way, I think he's getting at a very similar point, that if the court rules in a certain way, it's not because the law compels it, it's because of pure politics. And I think there's a risk when when presidents make those sorts of accusations while cases are pending. I think President Trump erred. I think President Obama erred. Trump, although, and to Michael's point, his tweets are very ill-timed and very poorly phrased, but the sentiment's much the same, that an adverse ruling is not based on the law, but based on some sort of political externalities.
Chris Grodner, back to you with BuzzFeed News. We talked earlier about how this has created a political problem for other
concerns that have been free, that to a case and you're not is damaging.
Yes, that's correct.
Back with Michael Dorff, with Josh Blackman, also with Thomas Mann at the Brookings Institution. First, we'll take a break. On our talking point later, from the ads to the end zone, politics were unavoidable at yesterday's Super Bowl. This is To the Point from Public Radio International. Is John Yoo. For those who remember the George W. Bush administration, John Yoo was the man in the Justice Department who justified the very vigorous extreme measures that were taken after September 11th, including the invasion of Afghanistan, the opening of the Guantanamo Detention Center, and the conducting of military trials and enhanced interrogation of terrorist leaders. I'm reading from something John Yoo himself just wrote in the New York Times, while he was saying at the same time, I have grave concerns about Mr. Trump's use of presidential power. Thomas Mann is with us, senior fellow at the Brookings Institution, co-author of It's Even Worse Than It Was, How the American Constitutional System collided with the new politics of extremism. Welcome as always.
Hi, Warren. Happy to be with you again.
How surprised are you about John Yoo taking the position that he is, having grave concern about what President Trump is doing?
Well, I think John Yoo be legally justified, but in general, Trump is
that the press is hiding
for actions, that tweets, the constraints of because Republicans are action. What goes on in this?
President Trump's income tax records in order
night was that but even at the time, the court said you can't just come in here and say the president with respect to national security, you can't just say it like a magic word and the courts go away. I think some of the tweets by the president suggest that he thinks otherwise, and it's not just the sort of off-the-cuff tweets. It's also the position that the government is taking in the litigation. I think that will probably fail, which is not to say that the federal government will necessarily lose the case, but I think that the courts are not going to accept these blanket assertions of national security, given the precedent, and frankly, given the lack of credibility of this president in particular. Although that's not going to appear in any of the written opinions, you can be sure judges will be thinking that this is a president who says stuff without necessarily having evidence to back it up.
Very quickly, back to Josh Blackman at South Texas College of Law. We heard at the beginning of the program that a judge in Seattle made this ruling. He asked the government and the various states and other parties involved to bring in arguments, but the government went directly to the appellate court, the Ninth Circuit a court. What do you think that court is likely to do? It now has asked for briefs as well.
So I think the Ninth Circuit, for reasons Chris mentioned, is probably going to dismiss the appeal, not because I think it's meritorious, but that's an easy way to get rid of it and deal with it perhaps later if there's any question about jurisdiction. The big choice confronting the government is whether to run to the Supreme Court or let the process play out. There's a risk by running to the Supreme Court tonight in that there are only 8 justices, and to issue a stay, you need 5 votes. There may not be 5 votes, and if the court doesn't grant the stay, that signals that this is maybe a loser of a case. The more prudent course would be to simply let the courts run out and in 90 days issue a final executive order, this is only temporary, and litigate that one. But that's the prudent course. President Trump is not the most rash person, so it's very likely he will demand they go to the Supreme Court. If they do that, it's unclear if there'll be enough votes to stop it tonight.
Thomas Mann, the issue of credibility was brought up in terms of how judges might feel.
At 40, that in the story means to us, of which we haven't been balanced.
Those illegal votes that were all cast.
Of course, it probably never happened. The reason why is the case was.
I want to go back to Josh Blackman. Speaking of President Jackson, he got into a lot of fights with the courts. He said that the Supreme Court had made a decision, let them enforce it. What precedent is there for the President of the United States to really get in down and dirty with the U.S. Supreme Court?
Well, the famous case of Worcester versus Georgia, where Marshall apparently said John Marshall made his ruling, let him enforce it, probably never happened. The reason why is the case was Worcester versus Georgia. The U.S. government wasn't even a party to the case, so it would have made no sense. Marshall couldn't have forced him to do a damn thing. A better example involves perhaps Abraham Lincoln, who had the Dred Scott decision. And what Lincoln said was this: the case was Dred Scott v. Sanford. These are 2 parties, and I will simply limit Taney's decision to those 2 parties, and no one else is bound by it. And this is actually a species of argument the government has advanced at various points in American history. As of yet, though, we've not seen any effort to try to limit the injunction to the 2 parties involved, or even to the district they're involved. Immediately after Judge Robart's decision, the Customs and Border more or less started complying with it. But going forward, I still think remains to be seen exactly whether Trump be willing to defy the court. My sense is it's not quite. And if you actually read John Yu's post, and people with the New York Times read past the headline, Yu does say that this policy is lawful. He speaks about other policies that haven't actually happened yet. So, we can worry, but I think he still has lawyers surrounding him who are still advising him somewhat. And I haven't seen any evidence yet that we're going down this road, but we'll keep our eyes open.
All right, law and politics. We all like to think that they are separate things, but maybe sometimes they are not. Thank you all very much for being on our program today. Josh Blackman again at South Texas College of Law. His latest book, Unraveled, Obamacare, Religious Liberty, and Executive Power. Thomas Mann at Brookings Institution. It's even worse than it was, how the American constitutional system collided with the new politics of extremism. Michael Dorf at Cornell Law School. He blogs at Dorf on Law. Thanks to all of you, and thanks to our earlier guest, Chris Geidner with BuzzFeed News. Great to have you all. In a moment, it sounds like it's a change in tone and substance, but in many ways it's not. We're going to talk about politics and the Super Bowl. To the point from Public Radio International.